Hey Chanakyans of grade 8, welcome to the video session. In this video, we are going to learn Civics chapter 6, that is about understanding or criminal justice system. Understanding or criminal justice system. In this, we are going to learn how the criminal system works and what are the roles of police and the police station. Understand? Yes. Shall we move on to the lesson? Okay. Yes, children, in this lesson, we are going to explore the following topics. They are introduction, what is a crime, two types of crime, key players of criminal justice system, and fair trial. These are the topics we are going to discuss in this video. Okay, yes. First, let's move on to the introduction. Okay, so in this, we are going to learn about the criminal justice system in our country. Is it clear? Yes. Let's see the video.
What do you feel when someone violates the law? Do you think of handing him over to the police? Have you ever thought how the criminal justice system of India works? When a person is held accused in any criminal act, police files a charge sheet in the magistrate's court. The court gives a copy of charge sheet including statements of witnesses to the accused. Then the accused has to hire a lawyer to defend himself in the line of evidences and witnesses in the court. What happens if the accused could not afford a lawyer? Does our constitution have any provision for such cases? According to Article 22 of our constitution, every person has the fundamental right to be defended by a lawyer. Article 39A states that government shall provide lawyer to an accused who is poor or disabled to engage an advocate for himself. Article 21 guarantees right to life or liberty, ensuring fair trial for everyone. Therefore, an advocate is appointed by the magistrate for accused at the expense of government. In the court trial, public prosecutor presents case against the on the behalf of the state. Both defense lawyer and public prosecutor produce witnesses and evidence in favor of their cases. The judge hears the testimony of lawyers, witnesses, and the accused. His judgment in the light of true law. So, we can say that there are four pillars of the criminal justice system, which are the police, the public prosecutor, the defense lawyer, and judge.
Yes, now let's see what is a crime. Do you know what is a crime? A crime is an offense against a public law. It is a harm to the society, a misconduct, and deal through formal sanctions. Okay, which means if we are doing any crime, for example, if you are taking others things, and if it happens to hurt others or doing all other harmful activities against the society, will call us a crime. Okay, yes. So there are two types of crime, that is cognizable and the non-cognizable offense. First, let's see the cognizable offense, which means a cognizable offense is a case in which police can arrest the offender without a warrant, which means offender means the person who commit the crime. Okay, yes. For example, murder, robbery, theft, kidnapping, dowry death, etc. Okay, these are the offense which can comes under the cognizable offense. Is it clear? And the law states that it is compulsory for an offense so officer in charge of a police station register an FIR whenever a person gives information about a cognizable offense, which means whenever a person comes, the affected person comes and complain about the victim, they have to take action against the offender. Okay, and then first they have to file the FIR means first information record. Understand? And who is the officer in charge of the police station? Who is the in charge of the police station? The senior most police officer available in the police station, that is SHO or his subordinate above the rank of a constable. Understand? He is the officer in charge or the duty officer. If the senior most officers cannot present, a sub inspector or head constable will be the officer in charge who will lodge for FIRs. Okay, so whenever if the senior most police officer is not available, even the sub inspector and head constable can make the FIR. Understand? Yes. Next, let's see the second type of offense, that is non-cognizable offense, which means the people who is making harm to the society. For example, these crimes are relatively of less serious nature and police officer not authorized to arrest without warrant. In this case, without arrest warrant, they cannot arrest a person. Okay, and police cannot investigate such an offense without permission of court. So in case if they want to arrest any person under this offense, the police has to get the proper order from the court. For example, public nuisance, causing simple hurt, and then mischief or more. See, for example, here in this picture you can see making so much of noise in the society, and the factories who's making a loud noise and who's disturbing the society will comes under this kind of offense. Understand? And see here, key players of criminal justice system. What is the key player of criminal justice system? Yes, we are going to watch a video for better understanding. Shall we watch? Yes.
Let us understand the role of in investigating the crime. The most important function of the police is to investigate any complaint received. Investigations include recording statements of witnesses and collecting evidences for the crime. If the evidences are against the accused person, they file a charge sheet in the court. When a person comes to the police station to complain, the first thing done by police is to lodge an FIR for the complaint. The FIR usually mentions the date, time, and place of offense, including the description of the event. The FIR also means the name and address of the complainant, the identity of the accused person. It is also mentioned. The complainant also has a legal right to get a free copy of the FIR from the police. The police investigations should always be conducted with words of law and with full respect to human rights. According to the Article 22 of the Constitution, the arrested person has various rights. He should be informed of the offense and needs to be presented before magistrate within 24 hours. No one will ill-treat or torture him in the custody. Confessions made in police custody are not to be used as evidence against him. Persons under 15 cannot be called to police station for mere questioning. In the court, the public prosecutor presents the case on behalf of state and presents all facts, witnesses, and evidences before the court in impartial manner. The judge conducts the trial impartially. Role is to analyze the evidences in the light of rule of law. He considers the statements of all the witnesses and the evidences that are presented during the trial. He then decides whether the accused person is guilty or innocent on the basis of these evidences. Then he gives a judgment on the basis of court proceedings and pronounces sentence in the form of punishment or fine or both. Now, let us understand what a fair trial is. According to Article 21 of the Constitution, a person's life or liberty can only be taken away only by following a reasonable legal procedure. Whenever a trial takes place, it should be held in open court in presence of the accused. The accused is defended by a lawyer. All witnesses should be cross-examined by the prosecution. The judge should give his judgment in an impartial manner.
Yes, now let's see the types of bails. There are two types of bail, such as cash bail by depositing cash in the court, and surety bail when a person stands guarantee for your presence in court. These are the two types of bails. Okay, and let's see what is fair trial. As you saw in the video, the fair trial means after collection of evidence, report is sent to court for trial. Once they finish collecting the evidence, they will be sending the report to the court. During trial, accused is informed about the charge. Okay, they will be informing about the charged to the accused. Okay, and she or he is allowed to cross examine witness. They will be allowing them to cross examine the witness, and she or he can also bring witness for his defense. Even they also can bring the witness for their defense, and if charge not proved, accused is acquitted. Okay, if charge proved, accused can appeal. Okay, let's see the MCQ so far what we learned. Okay, let's try to answer. During the trial of an accused in a court of law, the interest of the state is represented by the judge, the police, or the public prosecutor or defense lawyer. Can you guess the answer? Yes, the answer is public prosecutor. The answer is public prosecutor. During the trial of an accused in the court of law, the interest of the state is represented by the public prosecutor. Understand? Fine. Next, let's recapitulate the lesson. We are going to recapitulate the lesson. First, we learnt about the policeman, isn't it? Yes. If a person is arrested by police. It is a court of law that decides whether the accused person is guilty or not. Okay, whether they are guilty or not, they will be deciding. The court of law will be deciding the person who is arrested by the police is guilty or innocent. Okay, and according to article 22 of the constitution, every person has a fundamental right to be defended by a lawyer. The article 39A of the constitution places a duty upon the state to provide a lawyer to any citizen who is unable to engage one due to poverty or other disability, which means a person who committed crime or who is arrested by the police, if they are not able to offer a lawyer in behalf of their self, even the state to provide, it is the duty to the state to provide a lawyer to the citizen because of the poverty or other disability. Because of these reasons, if he cannot offered a lawyer, the state government will be provided the lawyer to him. Okay, and the police investigation any complaints about the commission of a crime, the first information report, that is FIR, should be mentions the date, time and the place of the offense. Okay, in the FIR they should mention all these details like date, time and the place of the offense, and also details that basic facts of the offense. Basic facts of the offense also should be mentioned in that FIR, and including a description of the event. Even they have to write the description of the event. Understand? And a criminal offense is regarded as a public wrong. If it is regarded as a public wrong, the public prosecutor represents the interest of the state, and his or her duty is to act impartially and present the full and material facts. Okay, and the witness and evidence before the court, so they have to act impartially. They should not have a partiality. They have to act impartially, and they have to provide all the materials, facts, witness and evidence before the court. The judge decides whether the accused person is guilty or innocent on the basis of the evidence presented and in accordance with the law. Okay, according to the evidence, he will be deciding whether a person who is arrested is guilty or innocent. Okay, the rule of law which says that everyone is equal before the law. No one is above the law and no one is under the law. Each and every citizen are in front of the law, are equal, isn't it? Yes, it would not make sense if every citizen is not guaranteed a fair trial by the constitution. Okay, fine. Let's see the glossary words. So in this, you learnt about evidence, investigation, public prosecutor, and witness are the new words, isn't it? Yes. So let's see what are the meaning for these words. First, evidence, which means a thing or things helpful in forming a conclusion or judgment. To write a judgment against a person the who is arrested by the police, they will be collecting the evidence. Okay, yes, this is the thing which helpful for the judge to write the judgment. Understand? Yes. Investigation, the process of inquiring into something through thoroughly and systematically. So the police will be getting the information, and they'll be inquiring about the information about the crime thoroughly and systematically by the name of investigation. Understand? And public prosecutor, a government official who prosecutes criminal actions on behalf of the state or community. The person who represents the state or the community as a lawyer, okay, and witness, one who can give a first hand account of something seen or heard to furnish evidence. And witness means the person who witnessed the crime, who who saw the crime, or who can say the truth, okay, he is the witness. Understand? And let's see little insights about the lesson, okay, in this rule of law. In this rule of law means that all governmental decisions shall be made in accordance with the legal principles. So we have our own legal book, isn't it? Rules and laws will be there in the book. There, according to that, the governmental decision shall be made, okay. And AV Daisy and Aristotle are the famous philosopher who were in favors of rule of law, okay. And rule of law implies that all citizens are subject to law, and no individual or group or institution is above law, okay. No one is above the law. Each and every one are equal, and there shall be supremacy of law, okay. There shall be supremacy of law. And let's see what is subordinate codes. Most of the legislation cases of the people are decided by the subordinate court, that is district court or tahsil level court. These courts are subordinate to the state high court. These are the subordinate to the state high court, and they hear both civil and criminal cases. Both civil and criminal cases. Okay, in your previous lesson we learnt about civil and criminal cases. Do you remember that? Yes, the district judge and the session judge are the heads at the local level. They are the heads at the local level, and the district judge hears the civil cases and the session judge hears criminal cases. Is it clear? Okay, children, let's recapitulate the lesson again by the mind map. We are learning the lesson understanding or criminal justice, isn't it? Yes, under this lesson, we learned about investigation a crime, public prosecutor, role of judge, isn't it? Yes. So, investigating a crime. Investigating a crime means the function of a public is to investigate crime. Investigation includes statement of witness and collection of evidence. It helps the police to form an opinion. The judge has the right to decide whether a person is guilty or innocent. Okay, and under that we learnt about Supreme Court guidelines, isn't it? Yes, the Supreme Court guidelines are the police investigations have to be conducted in accordance with the law and with full respect of human rights. Police must follow rules of detention and interrogation at the time of arrest, okay, and they cannot give any form of punishment for petty offenses, okay. The police should not touch or beat or ill treat the person, okay. And see here article 22 of the constitution. Under this article 22 of the constitution and criminal law guarantees every arrested person certain fundamental rights. There will be certain fundamental rights. So if you learn more about it, see here, right to be informed before a person is being arrested. They have to be well informed in the advance. Right to be presented within 24 hours of arrest before the magistrate, and within 24 hours they have to produce the person in front of the magistrate, okay. Police do not have any right to torture the arrested person when he is in police custody. Okay, when the person who is arrested by the police, when they are in the custody, they should not ill treated or they should not be tortured. Okay, and children under 15 and women cannot be called to the police station for questioning. Okay, the small children under 15 and the women cannot be called to the police station for questioning. Understand? Yes. So next let's see public prosecutor. A criminal offense is one considered committed not only against affected victims but also against the society. In the court, the public prosecutor presents the interest of the state. He presents the interest of the state. And what is the duty of prosecutor? On the basis of public investigations and the police charge sheet in the court, the prosecutor conducts the prosecution. Okay, and he presents the material facts, witnesses, and evidence before the court to enable the court to decide the cases. Okay, this is the duty of the prosecutor. Move on to role of the judge. The judge hears the cases impartially. He hears the witnesses and evidence presented by the prosecution and the defense. The judge then decides whether the accused is guilty or not. If the accused is convicted, the judge pronounces the sentence. The judge pronounces the sentence. Is it clear? Yes. And first trial, under this role of judge we learnt about first trial, isn't it? Yes. What is first trial? In a first trial, several different prosecutors have to be observed. Article 21 of the Constitution guarantees the right to life, which state that a person's life or liberty can be taken away only by a reasonable and just legal procedure. Okay, yes. So let's move on to the glossary. So under this glossary you learn the meaning about investigation, evidence, testimony, public prosecutor, and witness, isn't it? Yes, these are the four words new to you. Okay, yes. What is investigation? The action of investigating something or someone. Formal or systematic examination or research is called investigation. And evidence. Evidence means the available body of facts or information indicating whether a belief or proposition is true or valid. Testimony, which means formally written or spoken statement, especially in a court of law. Public prosecutor, law officer who conducts criminal proceedings on behalf of the state or in the public interest. Okay, and the last, witness, person who sees an event, typically a crime or accident, take place. Is it clear, children? Yes. Okay, children, we came to the end. We'll meet you in the next video. Thank you.